And this afternoon, the Supreme Court, in a landmark ruling, has actually declared Parliament's Standing Order 18 Clause 3 as unconstitutional. This ruling actually implies that the first Deputy Speaker, Joseph Osei-Owusu, retains his original voting rights as Member of Parliament. This also validates the approval of the 2022 budget, which was done by a one-sided majority in December last year. Opinions are actually divided over the propriety otherwise of the Bekwai MP's interpretation of the constitutional provision, leading to fisticuffs which we witnessed in the chamber when he attempted to vote on the subject of the controversial electronic transaction levy. Court correspondent Joseph Akable has been monitoring proceedings from the Supreme Court today and comes through with this report.
Two main issues engage the attention of the judges. The first had to do with whether or not the Deputy Speaker can be counted as part of quorum formation for parliamentary decision making. The court answered that question yes, indicating that the Deputy Speaker can be counted when a quorum is to be formed for parliamentary decision making. The second issue has to do with whether or not the Deputy Speaker can vote in terms of a decision-making process in Parliament. The court said that whether presiding or not, he retains his right to vote. Therefore, the court concluded that the approval of the 2022 budget on November 30, 2021 is valid. The Attorney General Godfrey Yeboah-Dame says he expects Parliament to abide by this decision, and the chaotic scenes that marred the parliamentary procedure will be a thing of the past.
The reason by the Supreme Court clearly is sound, is in accord with the practice in other jurisdictions around the world, and also clearly borne out by the letter and spirit of relevant provisions of the Constitution.
This applies to forming of quorum for business as well?
Yes, because indeed the Constitution itself was quite clear. Whenever it seeks to exclude a member presiding, it says so clearly. So you see that for the commencement of business, ordinary business in Parliament, it says with the exception of the person presiding. But such exception is not made in the case of forum for decision making. So when it comes to forum for decision making, the member presiding, if he's a member of Parliament, clearly will be included in the record of the quorum.
In terms of subsequent parliamentary business, I mean, as Minister for Justice, you expect that this will resolve the matter and avoid the scenes that we saw when the Deputy Speaker attempted to vote previously?
Oh, yeah, definitely, yes. I mean, those scenes clearly were needless and were really inspired by mischief, because all those mischief makers should have known that the practice in other jurisdictions, whenever the person presiding is a member of Parliament, that person is not precluded from exercising his right to vote, exists. So I think those scenes of Parliament were really unwarranted, and we really hope that they will not be repeated again. The Supreme Court has brought clarity on the matter, and it should guide the nation going forward.
Private legal practitioner Justice Abdullahi, who filed this case, has been reacting as well.
There are only two outcomes. It's not like a football game where there will be a draw. There will either be a win or a lose. But in this case, I think there's actually no one lost, because I think the Constitution wins, the people of Ghana win, and this is the best decision that I think we should have had. It puts clarity on the law, but despite the fact that some of the reliefs that I was seeking were not obtained, but there's a far-reaching decision that has been made by the Supreme Court today, to the extent of striking out portions of the standing orders, and this is very good for all of us. It puts clarity on the rules of Parliament, and indeed it makes all of us citizens. And I think I would probably use this opportunity to invite all of us to be participants in the democratic credentials of this country. We all have to play our roles to ensure that we get the best outcomes of our constitutions. This is just one of the things that we'll be doing going forward to ensure that the difficult decisions in bringing the sort of cases to the Supreme Court for clarity to be put on some of the issues that borders on sometimes illegality are all put to the past.
It is not clear whether government will send the e-levy bill to Parliament anytime soon, but it has been one issue that has been thorny in the last couple of months. For joining us from the Supreme Court, my name is Joseph Akable.
Well, so that's what transpired all throughout the day when Akable was in court monitoring all of the proceedings. But we need to give you some highlights of the decision that's coming through from the Supreme Court as we speak. Here's the implication. We know that the matters that were before the court was for the interpretation of the 1992 Constitution, Article 102, which you have on your screens as we speak, indicating that a quorum of Parliament, apart from the person presiding, shall be 1/3 of all the members of Parliament. And you recall that late last year, that became a subject of controversy when the first Deputy Speaker decided to add himself to the number of MPs in the chamber and deciding on the approval of the 2022 budget. But there's also another issue about Article 102, 104, which you should have on your screens now, indicating the procedure of voting. What you have now should be Article 104, actually, and it talks about the fact that except as otherwise provided in this constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting with at least half of all the members of Parliament present. Point 2 talks about the Speaker, which obviously the Speaker of Parliament we know is Alban Bagbin. He shall have neither an original nor casting vote. And it goes without saying that the Speaker of Parliament is not a member of Parliament. So that explains why that provision is there. But point 3 is where all of the controversy is stemming from, which actually translates into the standing orders, which we will be bringing to you shortly. But look at Article 104, Clause 3. It talks about the fact that where the votes on any motion are equal, it shall be taken to be actually lost. But that's not where the whole issue is. What we need to bring to your attention is what's contained in Article 104, which talks about the first Deputy Speaker. We'll be breaking all of that down for you shortly, but you need to stay with us because we also need to bring you the standing orders which the Supreme Court is today striking out. So we can bring you what the standing order also says about what should happen anytime there should be a vote in Parliament. So we'll bring you the standing orders, which you need to be very much aware of. The standing orders now, 1081. No question for decision in the House shall be proposed for determination unless there are present in the House not less than one half of all members of the House, except otherwise provided in the Constitution. The question proposed shall be determined by the majority of the members present. And all of this is being held from Article 104. But here's what the point is. Mr. Speaker, as we know, who is Alban Bagbin, will neither have an original nor casting vote. And if upon any question before the House, the votes equally divided, which means 50-50, the question shall be taken to be lost. So that's the implication number 2 with the standing orders 1093, which is being struck out by the court. But here's where the decision is. A Deputy Speaker or any other member presiding shall not retain his original vote while presiding. And that is exactly what the Supreme Court are now today indicating, that portions of that in the standing orders is unconstitutional, which means that obviously that would not stand. So what's the implication of all of this, and what's the reaction of minority to this? In fact, the minority has been speaking on the matter already. The minority in Parliament has actually criticized the ruling, adding that it will resist any attempt actually to pass the electronic transaction levy. Haruna Idrisu is the leader of minority in Parliament.
Attention has just been drawn to a ruling of the Supreme Court on the matter as to whether a person presiding as Speaker, consistent with Article 102 of the 1992 Constitution, which provides for the quorum, and Article 104, can exercise a vote whilst presiding. Our attention has been drawn to a very disappointing ruling of the Supreme Court of Ghana, which more or less amounts to a judicial interference in time-tested parliamentary practice and established conventions everywhere in the world, in civilized democracies, including the United Kingdom. The presiding officer's vote is discounted. So it's not for nothing that Article 102 provides that a person presiding shall have no original nor casting vote. The Supreme Court, to put it aptly, this ruling is judicial support for e-levy, nothing more. judicial support for e-levy for a struggling economy.
Well, so there you have it. Minority Leader Haruna Iddrisu addressing the press a while ago after that landmark ruling came from the Supreme Court. You heard from Joseph Ackah-Blay. But what is the implication of this, and what do some legal brains think about this? Fortunate to have Bawku Central Member of Parliament Mahama Ayariga joining us live via Zoom. He is also a lawyer himself, also a member of the Constitutional and Legal as well as Parliamentary Affairs Committee of Parliament. Thank you, sir, for joining us. And also private legal practitioner, lawyer Bobby Bunsen. Let me start off with you, Honorable Ayariga. What's your impression really of the decision by the Supreme Court to allow First Deputy Speakers to have, first of all, their original voting rights and then have the ability to form a quorum?
Well, I don't know. Thank you very much for the opportunity to join you in this discussion, but I don't know the extent to which the Supreme Court would have benefited from arguments that position itself against first or second deputy speaker voting when they are presiding, because I know that Parliament did not enter appearance or even file arguments to assist the Supreme Court, and I think that that might be a major setback in terms of the ruling of the Supreme Court, in that it would have been better if Parliament had joined and then, assisted with arguments why we should have an arrangement in our Parliament that disenable the person presiding from voting. That's the first issue that I would
How
say.
about claims that at least Parliament was not a party to this matter, and this was much more a case of interpretation of the Supreme Court?
But it is an interpretation of the rules of Parliament, the proceedings in Parliament, how Parliament conducts its business. And so if we had Parliament participating, I think that that should have helped. But be that as it may, the court has given its ruling. We don't have the benefit of the reasoning that informed the ruling. Usually for constitutional law experts, that is what you wait and read to understand how the court came to the conclusion that it came to. As for just reading the black letter law and saying that 104 just mentions speaker, and so it couldn't apply to a deputy speaker, first or second, and it doesn't relate to the person presiding, is something that I believe they should have provided some clarity to the whole idea that the person presiding at any given time becomes the speaker. And there are different circumstances when somebody is speaker. I mean, we have a situation where the speaker is out of the jurisdiction, and it is announced to Parliament that the speaker is out of the jurisdiction, and then the first deputy speaker assumes the position of the speaker. And this is also announced to the House. That situation might be different from when the speaker is sitting in his office and says, first deputy, you can preside, and then, I can come in.
It appears we're having some challenges to his connection there. We'll try and rectify the lines and get an understanding from the Honorable Mahama Ayariga. Lawyer Bobby Bunsen is also with us. So here we are. This is a matter of judicial review. Initially, we knew that the Supreme Court was going to give an interpretation to this. It would definitely have implications going forward in how a lot of activities are carried out in Parliament. But knowing that there's the concept of separation of powers, how is this going to play out for you, and what's your prediction going forward in the coming days in Parliament?
Thank you for having me. I was looking at, okay, as the standing rules exist, whether or not the actions or what was sent to the Supreme Court to be interpreted would the unconstitutionality aspect of the standing rules, so that before this decision of the Supreme Court had been given, will it have retrospective effect? Like Honorable Ayariga said, I have not had the benefit of seeing the reasoning behind or that underlined the decision of the Supreme Court. But I would want to see how they are going to marry the two scenarios. And so at the time that the decision or the first Deputy Speaker decided to participate in voting, the standing rules were there. Whether it was interpreted at that time to mean that, okay, if we do not declare the standing rules a nullity, are they valid? Are they enforceable? If they are valid and enforceable, will it deny the first Deputy Speaker the right to vote or form the quorum for the purposes of a decision making? So because whether the decision of the Supreme Court would have retrospective effect to mean that everything or whatever decision that has been done with the first Deputy Speaker is deemed valid, and whether going forward what ought to be done. Remember, Parliament is a master of its own rules. Will Parliament be able to sit and say, okay, this is what the Supreme Court has said. They have not prohibited us from amending the standing orders to bring clarity and to make it in compliance with the Constitution as they have directed. And so I want to see how Parliament will decide if they choose to amend the standing orders to bring it in line with the interpretation given by the Supreme Court, and whether or not the decision of the Supreme Court will be interpreted and applied to have retrospective effect to the extent that whatever was done by the first Deputy Speaker of Parliament would be deemed to have also been unconstitutional or constitutional. So once we all have the benefit of the reasoning behind the decision by the Supreme Court, perhaps we'll be better placed to...
Fortunately, the Honorable Mahama Ayariga is still with us. So let's find out from him, because he's the Member of Parliament, obviously on the Constitutional and Legal Affairs Committee as well. For you, Honorable Ayariga, what do you see as the way forward in Parliament, knowing that Parliament is a master of its own rules? Are you likely to go ahead and implement what it is that the Supreme Court is ruling on right now?
Hello, can you hear me?
Yes, we can, loud and clear.
Okay, yes. So I was saying that there's a difference between when the first Deputy Speaker is just a first Deputy Speaker in the presence of the Speaker. But there's also a difference when the first Deputy Speaker is acting as the Speaker when the Speaker is out of the jurisdiction. Because when the Speaker is out of the jurisdiction and the first Deputy Speaker is presiding, he, in essence, is the Speaker. So that's why I'm saying that we have to wait and listen to the reasoning of the court. I share the position that if the language of the Constitution is clear and the standing orders have provisions that are contrary to the express provisions of the Constitution, of course, the Supreme Court will declare the standing orders null and void. The standing orders do not supersede the Constitution, and the principle that Parliament is master of its own rules doesn't mean that when there are express provisions in the Constitution, it doesn't mean that when there are express provisions in the Constitution, you can go and then pass standing orders.
And we seem to be having some challenges there. So that's the explanation we're getting from Honorable Mahama Ayariga. For you, Lawyer Bobby Bansing, he says there's a difference when the Speaker is not in the jurisdiction and when the Speaker is also around. There are two issues at stake here. Looking at the ruling that we're having from the Supreme Court, really, does it really change anything? That's the question there.
Well, like I said, it depends on... Yes, of course, the Supreme Court decision is law, and it will bind Parliament going forward. So yes, it will change. It will change a lot of things. But whether or not it will affect what has been done in the past, it's what I'm yet to see, because we do not have the benefit of the full reasoning. Be that as it may, like I said, reading the standing orders as it was then, together with the Constitution. I thought the two could be read together, and I did not see any constitutionality with it, with the two of them being interpreted and applied together. And I sided with the position that said that the first deputy speaker, once he is presiding, would have all the rights and liabilities, as it were, of the speaker, and so will not be able to constitute a quorum. But the Supreme Court has delivered its decision, declaring the standing orders, those provisions, as unconstitutional. It will definitely change how Parliament conducts its affairs going forward, unless Parliament, like we say, we keep saying, master of its own rules, decide to amend the standing orders to bring some clarity into the issue, and then make sure that it's aligned with the provision, the ruling by the Supreme Court, and we'll see how that pans out.
Lawyer Bobby Benson, I'm grateful. Let's take you now to Parliament, where my colleague Parker Wilson is monitoring events for us live, and he joins me now. Parker, I can imagine the mood in Parliament now, mixed reactions. Obviously, the majority side will be elated about this because this will add to their numbers. Tell us more about the indications we're getting, not just from the minority, but also the man at the center of this, Joseph Osei-Owusu himself.
So, Blessed, I'm making the point that the majority in the House is elated and are gloating over the decision by the Apex Court. Now, their position is that the judgment delivered by the Supreme Court affirms the position of the first Deputy Speaker of Parliament, Joseph Osei-Owusu. And he himself described the judgment as refreshing, as something that he was expecting, because he has always maintained as a lawyer that he never erred when he indicated to the House that as a member of Parliament representing the people of Bekwai, he has every opportunity and has every right, legal right, to partake in any voting decision on the floor of the House, whether or not he is presiding over sittings. And so what the Supreme Court judges have done is to bring finality and clarity to an issue that became a subject of controversy in the chamber. And he is expecting his colleagues on the other side, particularly the minority, to accept the decision and work together for the interest of the nation. He disagreed with the position by the minority leader that what the Supreme Court has done is an interference of parliamentary procedures, but rather it is something that will further deepen parliamentary practice. So that has been the position of Joseph Osei-Owusu, Member of Parliament for Bekwai, and of course, the first Deputy Speaker of the House. But I must say that the minority is super upset. They are incensed over the ruling and have accused the judges of intellectual dishonesty. They believe this is a judicial support for the approval of the e-levy, and they will resist the e-levy at any point in time when it is tabled before the House for consideration. I must say that a Member of Parliament for Ningo Prampram, being a member of the minority caucus, has served notice that for him, he will ensure that they protect parliamentary practice. What he believes is the judgment is actually flies in the face of parliamentary practice. And for him, on any given day, he will protect the democracy of this country by resisting any attempt by the first Deputy Speaker or the second Deputy Speaker to partake in the vote. But I must say that his colleague on the other side, Eugene Boakye-Nchi, has dared the minority to try to resist this position, because if they do, they will equally resist. They want the minority to accept the ruling and work together. So going forward, it'll be quite interesting in the chamber, because the minority has served notice that they will not comply. Parliament is a master of its own laws and its own ruling, and that the Supreme Court cannot tell them what they have to do. The majority on the other side is also saying that the Supreme Court has been given the mandate to interpret the Constitution, and they have interpreted the Constitution to the best interest of this nation. So going forward, it'll be quite interesting in the chamber. But there is another school of thought that perhaps the Parliament should not consider appointing second or deputy speakers of the House outside Parliament. If you appoint deputy speakers of the House who are outside Parliament, we won't have this challenge, because you cannot be a referee in your own a football match. That is how the minority simplified this judgment. So they are clear in their minds that this particular ruling does not augur well for parliamentary practice, and they will resist it.
Parker, break this down for us. What would this mean, first of all, for the numbers in Parliament? And we do know that the first Deputy Speaker himself has been commenting on this matter, indicating that this would mean victory for democracy. How about that?
Well, he said that this will mean the victory for democracy, and basically because now there is finality, there is clarity on this matter as to whether or not if you are a member of parliament and presiding, you are prevented or precluded from partaking in a vote in the chamber. And so it is not just for him, but for any other member of parliament who presides during sitting. And he indicated to us that it wouldn't be the process where he has to get up from the seat and make way for the second Deputy Speaker of Parliament to come and chair before he can cast his vote. Whilst on the seat, he can indicate to the House that I am voting A or I am voting B. And so that wouldn't be an issue at all. He will still be presiding and indicate to members of the House that because he agrees with this decision, he is voting in this direction. And so this is a victory for democracy. He is clear in his mind that what the Supreme Court has done does not fly in the face of the standing orders. It is not an error, it is not dishonesty, but rather something that would go a long way to assist Parliament work together. But the minority has a different view. Tonight or this afternoon, they have served notice that any attempt by the first Deputy Speaker or the second Deputy Speaker of Parliament to partake in any vote, because the argument has been that if you are presiding over sitting, you are not supposed to debate as a speaker. And so if you don't debate, how then do you partake in a vote that is happening in the chamber when you did not partake in that decision making? Besides, when a call for division is done, it is basically because the speaker wants to have the clarity of the yes vote or the no vote is the reason the division is called. And so if you did not vote via voice vote, why then do you include yourself or partake in any decision when there's a division or a head count? That has been the contention of the minority in this. And for the Supreme Court, the minority believes that it was a misinterpretation of Article 102, which talks about a member of parliament can be counted to form a quorum even when he is presiding. And then again, a deputy speaker or deputy speakers can equally vote. The minority believes that the law has been twisted to suit the NPP and their members in the chamber. So they are obviously going to oppose to any actions from the majority side in this regard.
Wilson joining us live from Parliament and giving us the very latest on this that we're keeping our eyes on, the Supreme Court ruling and allowing the first Deputy Speaker of Parliament now to have his original casting votes. Parker, thank you.